Good afternoon, everyone, and welcome to the Samvaad series of talks on data privacy at IIIT-Bangalore. Our participants in the room and in the Zoom meeting. We are honored to have one of the most eminent authorities on the subject to address us today, the Honorable Justice Srikrishna. And I invite Professor Janaki Srinivasan to introduce our guest. Justice B. N. Srikrishna started his career as an advocate of the Bombay High Court in 1962. He was elected as a member of the Bombay Bar Association, the International Bar Association London, and the Industrial Relations Research Association in the US. He served as a judge of the Bombay High Court from 1990 till 2001, during which he was appointed as a one-man commission to inquire into the riots and incidents in Mumbai during December 92 to January 93. He was appointed as the Chief Justice of the Kerala High Court in 2001 and then as a judge of the Supreme Court of India in 2002 until his retirement in 2006. In his post-retirement career, Justice Srikrishna has chaired several influential commissions, including the Sixth Pay Commission and the Committee for Consultations on the Situation in Andhra Pradesh. He has been instrumental in shaping key aspects of India's legal and financial sectors through his work on the Financial Sector Legislative Reforms Commission and the Expert Committee on Arbitration in India. In 2017, Justice Srikrishna was appointed as the chair of the Committee of Experts by the Ministry of Electronics and IT to deliberate on a data protection framework for India, identify key issues pertaining to privacy, and to draft a data protection law. The committee submitted its report in 2017, and this formed the basis of the DPDP Act, which finally came out this year. And this is something that Justice Srikrishna will be talking to us about. In addition to all of this, Justice Srikrishna is a connoisseur of Carnatic classical music and has also authored several books on the history of the judiciary in India. With that, and without further ado, I will invite Justice Srikrishna to come and address. Yeah.
Thank you, Dr. Janaki. I welcome Honorable Justice Srikrishna to our campus, IIIT-Bangalore, to give a talk which is extremely important. Everybody knows data is oil, but that data is more costly than oil because of the information in that. So how to protect the privacy and all the information and how to work out a wonderful contribution. So thank you for giving us time and for your talk. And I also want to thank Professor Sridhar and Professor Janaki and also Professor Srikant, three pioneer person in our campus working on the privacy and the data. So for arranging this talk in this campus. Thank you.
Thank you, Dr. Das. Professor Janaki, Professor Srikant. And all the members of the faculty and the students here. It's a great pleasure to be here and to interact with all of you. My days I studied using data first night classroom, AV equipment, cotton lights and things like that. So I'm still I belong to the old generation. Look at all the youngsters here. I've been jealous that you have great opportunity which I could not get in my life. Anyway, now we come back to the inevitable subject. What is this data privacy that we are talking about? Somebody told me during one of the interactions, oh, this is something that was taught to us by the Europeans to the GDPR. You know what the GDPR, no? General Data Protection Regulations in Europe. I told him, sorry sir, let me boast that this concept has been there, conceptually at least, in our country, much before you have ever thought of it. He said, why? How do you say that? I said, way back, you have in Sanskrit a situation of a wise man teaching good things to the wayward princess of a king And that turned out into a classic book in literature in Sanskrit. And in that, one of the things he tells is, Ayurvidam Grihachidram Mantra Aushadamaithule Dhanam Manavamananja Navagopyani Gopaye. He said there are 9 things about which privacy must be guarded. They are your age. Then of course the ladies will understand that you never disclose the age. Wisdom, your bank balance. Every day we get don't tell them your PIN number, OTP and all. So when the bank balance is vanished. Grihachidram, your domestic product, you don't talk about it, keep it confidential. Mantra, the mantra that your guru has removed the message, you don't talk about it publicly. Your sexual life, you don't talk about it publicly. The accolade that you receive or the criticism that you receive is not really talked about publicly. So these are 9 things which the concept was the data about this has to be kept private. Now that is a great thing about privacy, concept of privacy. Now let's take a long jump from the time of 4th century and to the 21st century. What happened is, there was a lot of being aware and focused more on the legal issues than on the technical issues. The issue was, is there anything called a right of privacy? If so, what are its contours? 2-3 judgments came out, which really threw some light on that. There was a judgment from Madras High Court in which a doctor was treating a girl. A doctor was a family physician of a family of which a girl was married to a boy. And he happened to learn that the boy was suffering from AIDS. So he disclosed it to the girl's family, and that became a big issue. Matter came up to the Madras High Court. And the Madras High Court had to debate and decide whether the issue of health of this boy was something that had to be kept, private kept and led by the doctor, and whether there was a right of privacy with regard to it. Madras High Court said, no, the other interest requires, otherwise the girl's life would be ruined. Therefore, we was right, we don't accept the right of privacy. Then there was another judgment coming up from the Madhya Pradesh somewhere, where a person was kept under constant police surveillance. Wherever he got out of the house, wherever he went, whichever bus he took, or whichever shop he went to, he was constantly monitored by the police. So he went to the High Court and said, hey, this is infringement of my right of privacy. So I don't want to be subject to this, they should leave me alone. Then the court said, yes, there is a right of privacy. The police have no business to do it unless there is something really established or ascertainable about the criminal antecedents. And there were a couple of other judgments which went on pro and forth. Now, when these were happening, something of a revolution took place in our country. And that is the Aadhar. Now, Aadhar is a novel idea that was came about as a result of some brainstorming by people at the top, including Ananda Nilankan and others. I'm saying that every person in the country needs to have a digital identity, and that can be done in terms of a numerical tag that could get shared. To start with, please remember, Aadhar was only a departmental idea of the government of India. Subsequently, it was made some kind of a separate subset of the department, which went into this issue. It was only much later that an act was passed and a statutory backing was given to Aadhar. When this happened, as there were a number of social activists who said, hey, this Aadhar takes away my personal data and gives it in the hands of third party who doesn't guarantee that it's going to be kept secret. Therefore, it's an infringement of my right, my fundamental right to be precise. This matter went through the convoluted path of the Supreme Court and finally landed up with a large bench of 9 judges. We have to decide. That was the judgment of Puttuswamy. Puttuswamy was the justice of the Karnataka, retired justice of the Karnataka. He was a very social activist who filed this. When this came about, the question arose as to whether this is really a right at all, and if it is a right, is it a fundamental right? I take it that all of you know the distinction between a fundamental right and an ordinary right. A right can be natural. My right to breathe is natural, nobody is getting it. But my right to clean environment is a right that I can exercise against the state. Now, that is the fundamental right. Second distinction is that a fundamental right is something that is guaranteed under the Constitution and cannot be infringed or abridged except by a complicated process that is involved in the delineated in the Constitution itself. Whereas an ordinary right can be upset by Parliament passing an appropriate legislation. When this question was being debated as to whether it is a fundamental right at all, or whether it is a right at all, and if whether it was a fundamental right, one of the judges asked the Attorney General and said, "Hey, but what is the law of the country along this subject of the country?" Everybody looked around and said, "There is no law, there was no law at all." So it was on a Friday, it was on a Thursday. So they said, "We'll give you an answer." And then the matter got mentioned, that will come again on Tuesday. Because in Supreme Court, Friday and Monday admission matter, everyone here finally matter. So on Thursday evening, I was able to catch a flight to New York. I got an SOS from the minister, IT minister, saying, "Srikrishna ji, आप पे बहुत बड़ा काम करना है." I said, "What is it?" The previous law minister. I said, "What is it?" He said, "Supreme Court, after this question, you don't have a setup, you don't have a law. Therefore, we decided that we are going to set up a committee to go into this issue and tell us what will be the law in our law." I said, "Okay, I will go make a call and come back after a month and sort it out." Then I think so. You have to say yes just now. So we cannot go with that flight. Now I sorry, I have already passed here. I said, "Okay, I'm saying yes, I'm catching the plane and going." He said, "When you are there, we can have our video conference." So it's called my meditation act, video conference, and this but it helped because by the time I came back, I had a lot of conferences with Nanda, who was in Boston at that time, and some of the other persons, experts who were in India at that time. We did all this, and then the committee was set up, and a formal notification was issued, in which, as usual, the government secretary said, "You will give a report at the end of 18 months." I said, "Like, I'm not going to report for this kind of thing. This is too big a subject. I don't know where it's going to land. I don't know what are going to be the dimensions of the subject. Therefore, please remove that last line and say, you will do it as soon as possible." I will determine when it should be done. So, ultimately, the government notification for this. After the notification was issued, then we went on with whatever was to be done, the work after looking at what was happening, and we did a good thing. It should be really an administrative procedure. Whenever you are thinking of bringing about a law, what is the law for? Is the law for somebody who is sitting in a company and doing business? Or is it the law for somebody who is sitting in secretariat and carrying on his administration? The law, ladies and gentlemen, is for you. It is for a social interaction that the law is intended. Therefore, who should have a voice in this? You people should have a voice. Therefore, we said, we will go around, make some kind of a white paper, put it in public domain. We had about 7 meetings in various parts of the country. A lot of inputs were there. We addressed a number of letters to academicians, professors, practitioners, lawyers, judges, etc. Got a lot of input. And finally, in 2017, we introduced a report going into the various principles on which this entire structure has to be. We also came out with a draft bill. This could be, of course, modified and passed by contract. Now, what happened there is, 2017 bill ran into rough weather because the lobby of multinationals was very strong. They did not appreciate some of the principles that were at the bottom of the report. And finally, the bill submitted in 2017 was going round or kept unified till about 2018. And in 2018, the government came out with its own bill, which had an objectionable clause. Everybody was up against it. So it was referred to a joint parliamentary committee. The joint parliamentary committee then suggested 87 amendments. So everybody said 87 amendments, I don't know what might happen to it. Finally, the government said, let's not bother about it, let's pick out our bill, the bill was discussion. Then for another 5 years, nothing happened. People went back and forth, back and forth, back and forth. In 2022, the Data Protection Act, it's called the DPDP, that is Digital Data Protection Act, was passed in 2022. The Act has not yet been notified. It will be notified at some point of time and it will become operational from the date on which it is notified, either as a whole or in parts as the government has Now, this is the process of evolution of how the law was. Now, at the same time, in Europe, you had the GDPR, which got implemented. The last of it was in 2008, 17, 18, something, or 16, followed, yeah, because I was still doing the community work at 16. And thereafter, they have been able to continue to a large extent in Europe. America never had any law. Till recently, 2-3 years ago, I think, only the state of California has got it through the window of Consumer Protection Act. The other parts of the country don't have a law. There is no federal law in America. In fact, it was very heartening to know that all these Southeastern countries, the experts came to us and wanted to understand how to build this kind of a law. Even Korea did not have a law. Japan did not have a law. Singapore did not have a law. Now, every one of them had a law, but we were the last in the race, as usual. Now, some of the principles that I know that need to be carefully considered. Some of the jurisprudential aspects. Dr. Das here mentioned, hey, data is the new oil. This is very rough description, somebody come out with it, and Dr. Das just, it's not, he just repeated it. See, the point is, what is the concept of data jurisprudence is very interesting. Now, if I say that this is my pen, it's not a pen actually, it's a monitor of some kind. This is mine. What are you saying? In jurisprudential terms, when you use the genitive case is what you all understand what is genitive case is something that shows a relation. If I say this is my book, this is my work, this is my children, these are my friends, that is genitive. Genitive case usually is taken to be a proprietary ownership. If I say this is my house, this house belongs to me, I am the proprietor of the house. If I say this is my business, this is my company, this is my car, whatever this is. But that is not always true. Or if I say this is my wife, can I say this is I'm the proprietor of that lady? All the ladies take to job of and what nonsense. If I say this son is my son and I'm the proprietor of the son. Yes. So she will be only this family. Otherwise, it's a Papa what nonsense are you talking. And the last time the son was sold was very high standard. You are not telling me high standard, you can't sell children and wife as proprietors. So what does it mean? And I say this is my wife, my child, my hand. It means that there is an intimate relationship between the object and the person who is thinking. And if I say this is my hand, what are you? Not my hand, it's my hand. That means I'm not the owner. I am the person who has an intimate relationship between this and whatever I consider right. I is a philosophical concept, I will not go into it. We study it in the Vedanta context. Now, this is the way in which jurisprudence is done. So therefore, I concede that data results in a lot of generation of wealth, no doubt about it. Now, how it happens, we see in practice. You get up in the morning, somebody will be selling clothes, which send you an email. I don't know from where he got your email address or your mobile number, but he used it to sell his craft to you, generate an intention in your part to buy the item, and it gives you a lot of money. So that is how data can be converted into money or wealth or even property. Beyond that, to say that data is oil, no, oil is an entity which I can buy and sell. My data I can't sell. But take a simple thing. I'll give you an example. Can anybody answer me? My name is Srikrishna. My data, no doubt about that. Can I say that doctor, the class, I'll give it to you for 6 months, use it without, or give me rent for that? Or can I sell it to you and say, I sold it to you, because tomorrow you will see the name, I will not do that. You cannot do that with personal data. Yeah, I'm talking about personal data because the DPDP Act is only personal data, you understand? It doesn't record non-personal data, and non-personal data is a different question as in when it comes up to the fore. So, jurisprudentially, data is something that has an intimate relationship with a human being. And that relationship can be monetized into money. That's a different matter. That data itself is not money. Data itself is not property. This is something that one should understand. Once you understand that, then so many questions are it. The question is, whose data is it? Now, whose data in the question is, to whom does the data refer to intimate? Or if I say, Srikrishna, there are not so many Srikrishna, they are at justice. Okay. Justice Srikrishna is discharged. Immediately you can identify that this is the person to whom it relates. So this is my data. Now, there will be data of other kinds. Now, for example, my mobile number. When I went to buy a plane ticket, or a train ticket, or a cinema ticket. Now, because even cinema ticket also they ask for Aadhar. Compulsory for marriage, getting things that are yes. Aadhar is not there. Thank God I know, but marriage has for Aadhar. For registration for us. That is marriage is not registered at all. Sorry? Yeah, no, you're all living in this world. I am from 1941. So, you are right. When you go for registration, you will after Aadhar. So, the point is, you are giving that whatever is written in Aadhar, these are the data points. You are giving it to the register. For what purpose? For the purpose of registering a union between, or no, I have to say, same sex or different sex. Another problem. Another problem is mentioned now. Well, I'm an old man, let's talk it up. My wife and me, that they get to be married. So after the list out, I'm getting married to the area, all that already I'm married according to the ceremony, in the registration. Now the register notes down in those cases use the register. Now we'll put it on the register. Now they say, there is 100% who are married to. They have got full data set of 100 their mobile numbers, address, various other inputs. Now let me go and give it all to some saree seller in Chennai. So that he can make a lot of money. And you do that, he cannot do that. Because there is what is this known as that I am the data giver, I am calling principal data principal. Now originally, under the GDPR and that was fought all around the world, the persons whose data was being given was only data subject. I objected to it. I ceased to be a subject of anybody after 1947, not even a queen of Israel. I am an independent person, so don't call me a subject. My data, I am the data principal. You are taking the data, you are the data fiduciary. Please note the word fiduciary as a significance. Fiduciary, the legal term, means somebody who is under an obligation or trust to do something. What happens? When I give my data to some trader, I give it for A, for a specific purpose, B, with the understanding that he will keep it safe and not utilize it for anything other than the purpose for which it was given. C, at some time, I don't have the relationship of trader with me, please gather it from your records. These are the fundamental concepts which were built into the report. I don't know how many people in the report. And in the first bill that was submitted. These raises a number. The number, I'm sorry, I'm not going strictly according to this, otherwise I'm thinking this should be one changing. I have done this, that's okay. Now data may be of two kinds. One is critical, the other is sensitive. Critical is something that none of these bills are very monitored. What is critical data? Critical data is that data of a person who, because of the office, gets criticality. Now, let's take the President of India. The data of the President of India is critical data. They can't get out of Chief Justice of India or Chief of the Army Staff, something. Now, why it is necessary to identify it? I'll come in a moment. The other is sensitive. Sensitive is what? Now, if you just ask for my name, I go and anybody shakes hand, I'll tell my name, something. But beyond that, I'm not going to disclose the data about my health records or the medicine that I'm taking. That is all sensitive data. Nobody discloses that. Now, that is something which has to be treated different. Critical data has to be treated at a different level. Then we have processing of data. What is processing? When I give data to somebody, that's not normally understood as processing. Data subject, data principle, giving it to the fiduciary is called the process. For what? Now the processing is being defined in the law in an expanded manner. So if I give data to somebody and that person just gives it on a computer system, but itself is not processing it in the normal sense that we understand in common parlance. Law says even giving it there in your books, giving there in your computer system, in access processing. Processing can also mean that I hand it over to somebody else for doing some work on that. That person may hand it over to a third person, and it may go hand in hand, from hand to hand, even to the end, depending on the process. That is processing, carrying on something with it by which the data is used for generating a new product. Then you have transfer of data. How does data get transferred? My data can go to somebody. He said the basic requirement is my consent. Somebody cannot come and say, you are never Srikrishna, I'm taking it away. No. The least you can do is ask me and tell me. So consent is the bare requisite. But please note, consent is not the last word of that. Because there could be a situation where consent may be implied, where the consent may be enforced by law. Now take a situation. Either you go to a shopping mall or you want to go to a picture house. You will notice, or if you are not noticed, next time notice. There is a small camera which takes your picture. It takes it for good reason, security. Once you have entered the mall, you are inclined to have consent. Because you have a choice. If you know that there is, actually they should put up a notice and say, there is a good, otherwise you will not bother with a camera. If you know that there is a camera, and knowing that you step into the premises of the mall, you are impliedly consenting to your picture being taken, your data being accessed. And data can be transferred by other means also. Now, for example, if you are driving along a highway, you notice that these traffic cameras are there. Those traffic cameras constantly take a photo. That photo is your data. Your car and your data both are written. More than the car into your face, that's the data. Now, what does it do? It doesn't in order to ensure that the traffic laws are obeyed. Therefore, the law presumes that you are bound to give this, if you are using this particular highway. The choice is yours. If you don't want to use it, but you want to pass through case, formulate, and mark and come to IIT, that's what I think. You're welcome. Or you can use the electronic process. The road is there all the way. The choice is yours. But once you accept the choice and do it, you are deemed to have transferred the data. The transference of data has further nuances. The person may be injured and he may be admitted to the hospital. Now, hospital want to know his data, saying what is your blood group, what is your fertilization, what is your blood pressure, what is your, whether you have diabetes, whether you have this, that, and the other, what is your medication that will be given. All that is my sensitive data. Now, the hospital wants it for what purpose? For the purpose of saving my life. So even if I do not explicitly consent, I will blindly consent because I get it. Then there is a bigger question of transfer of data across the border of the country. That became a very controversial subject. The controversy is like this. Let us say there is a multinational firm which is doing business in India. It has an office in electronic city. Now there is some personal data of XYZ which needs to be accessed to the police because the police have strong suspicion that terrorists or he is financing terrorists. How do you get it? You walk up to him, let's say with a warrant from the court, and say, please show me this data of this, and I want my registered hotel, this hotel, which time, blah, blah, blah. Now the manager in charge of the company here will say, sir, I don't have it in my pocket. It is all in California, or it is up to wherever the server is located. My police officer, he has to go through what a complicated route known as email. No, not PMLS, it's called mutual assistance.
In CLTs.
No, mutual assistance. Mutual legal assistance. MLA. MLA. Now, treaty is between a sovereign country like Africa and a sovereign country like India. That in case of any difficulties arising where you have to give some mutual legal assistance, there is a certain procedure. That procedure is so complicated that it will originate from the court and then go into the executive body, then go to the river and post, and then go all the way to America and traverse that, and finally some judge just can be given. Then it comes back to the same route. In the earlier days, you must have noticed that people used to go from India to England, the ship and come back. That used to be done in 1 month, which takes 3 years. Sometimes even more than that. So, PMLAD is not, that MLAD is not good. Because you are changing a terrorist who is making bombs sitting somewhere. If you don't have him then and there, your whole purpose is gone. Therefore, it is necessary to have this data. Now, this is a big controversy because the only objection that was raised by all the MNCs to be that was they will increase the cost of doing business. Right? And ultimately, the cost of doing business will reflect on the individuals. That's fine. Cost of doing business is a static. I know why the world is income tax is not anything. People complain about it. You pay more and then pass it on. GST is paid 18%. Where does it go? It goes into the pocket of the fellow who pays for it. So what does it matter to you? Where is another 100 rupees? Let somebody pay for it. But at least the data will be secure here. Two options were suggested. One is either ensure that all the data of this country remains in this country. Or if you can't do it, let it remain wherever else. Have a mirror updated, mirror constantly updated so that it is accessible to this law enforcement authority. But as usual, these kinds of principles don't work in government. What works is push technology. So finally, the NMC and the so this was the latest act does not even talk about transfer of data. It only says that data will not be transferred to across the border where there is a blacklist. Blacklist is you shall not give it to Pakistan, you shall not give it to China or whatever. After that, you are free to do what you want. So, ladies and gentlemen, today your data can go to America, it can go to Australia. Whether you go or not is not critical. Your data can go to Australia, England, wherever. Germany. Now the next. Now, processing of personal data collected, shared, or disclosed or other processed in India. Now, I must mention that two of the regulators, even before all this talk came after the circus, had decided that all data will be generated here in remaining India. One of the Reserve Bank. The Reserve Bank issued regulation and circulars on that saying that all financial data regulated as a result of the banking transaction shall be maintained on a server only within India. And telecom has also had similar regulation. Being all telecom data will be maintained. Other than that, your data can be maintained. Then the next is what happens in this processing? Processing may be done by a private person, by a state entity. The original idea of the state, whether the data is processed by a state or a state entity or by an ordinary private person, the law should equally apply. Now, for reasons that are really unfathomable to me, the act which has come about says the government will have the power to exempt any government entity, any government department, any semi-government department, any section or all these sections of the act. Now consider this. There are certain sections which lay down what is the obligation of the data processor. What is the obligation of the data fiduciary? First obligation is when you get data from the maintain its integrity, ensure by an appropriate technical methodology that the data is not hacked, data is not unauthorized access. The obligation is not there. So if you give data to the state will say, why am I obliged? You can correct, you can hack my everybody, you can do everybody. Okay, I agree. I told you the limitation was process limitation. I give you data for this reason, you can't use it for anything. That is an obligation. You are exempted from the obligation. You can talk it out to anybody for whatever you do. This is another difficulty. Then, one of the things is it something that operates only within the country or is it capable of operating externally? Two exceptions. There are some laws in which exceptions are there. I don't know how many of you know that the Indian Penal Code has section 4 which operates extraterritorially. What is extraterritorial mean? If you go to, let's say, Dubai and commit an offense there, which is punishable in India, then when you come back, you'll get punished. Or if you commit a murder somewhere else, then you are liable to be punished here. Why? Because section 4 says it will operate extraterritorially. Similarly, as far as data protection is concerned, all entities, normally the law will operate only within the country. It cannot operate against somebody who is not here. So it's an American company or a German company or a Swiss company. I can't do anything about it. But if they are regularly sending information to entice or incentivize people in India, then the law says they will be treated as intentional in further purposes. So that is extraterritoriality. Then you have I told you the principle is first of all there must be consent from the consent can be see consent is like you come and ask me, will you give me 100 rupees? I will say, no. That means what? In law, nobody accepts his consent. Or I have to give it to you in writing. Similarly, here the consent has to be explicit. Explicit is the thing without any provision for a mistake. Now, this creates a little difficulty in this country. What is the difficulty? Let's say you are the data processor, he comes and asks me, you are just like me, and answer. Sir, will you give me data? I said, no English, only Hindi. You say, no, Hindi only. So I have to make sure, if I am processing the data, I have to make sure that the data principal understands whether he is being answer. So I have to go down to his language and say Hindi. There is no Hindi, EMP only. Then what do you have to talk to his public? Or yeah, Malayalam or Korea or whatever other language, Bengali. I'm mentioning before. So, how do you this number? Go one step ahead. There are people who can't read and write. What do you do? Therefore, you have to do them some kind of a graphic sign. Now, for example, when you want to say no parking, what do you do? You put a board P cross. Poisonous liquids. What do you do? You put a skull and ball in that board. Right, understand? Or you have something like no smoking. One cigarette cross. Something like that would be put across. Does a man understand what is being said? Go one step ahead. He doesn't understand anything at all. That's what we are discussing earlier. A person is incapable because of his mental condition to understand whether data is being given with his consent. That's a really complicated issue, and I don't have a ready answer to that honestly. That needs to be looked into a little more carefully. So that is the issue. Therefore, consent is the first step, but that is not the last step. Consent has to be explicit and in a manner that is understood, and it is to be informed consent. That is why still. So in the car, you have to say kabul, and yes. But we just even to make sure that he has understood he is getting married to the state. So consent is very important. Then accessing data without consent, that also is possible. You see, no research is possible without statistics. And no statistics is possible without data. So if I want to understand what is the impact of COVID on the people of Karnataka, does it vary with state to state? Does it vary with gender to gender? Does it vary with a particular age factor? Does it vary with other comorbidities? Each one of them is a statistics. So therefore, for such research purposes, data should be available. You can't say I did not. But there is a little variation. Now, if I go to hospital and I'm treated there, I'm discharged. My data will be there somewhere. Now, for statistical purposes, you might want to know how many persons were treated in this hospital. First class, no problem. But why should you know whether Srikrishna was treated? Not necessary to know. Therefore, there is what is known as the concept of anonymization. Anonymization is coming out with the process by which the data is not relatable to an individual. But all our technical principles tell you, anonymization is not a thing. Not a reverse engineering. But at least, as of today, we take it as good just anonymized. This is one happening. But if it is a statistical purpose, then you don't need anything else other than the number, actual number, without it was anonymized. So that is my exception. And another exception is, can you have anonymization and pseudonymization? All of you know the example what is it? They have take out your name and your number and some number and all that in order to examine and you don't know that. Have you not? You have all appeared to military examination, no? What is it doing? There is one tag, the tag is removed, and they attach another tag, and between the two, somebody gets off on this. Then when is minor stuff? Minor stuff is another big issue. The minor is somebody who is considered to be incapable of entering into a contractual relationship. Now, originally it was very good when the Privy Council gave judgment only in this case. But they have said, as far as minors concerned, this minors contract is concerned, it is invalid, no rights to law. Neither can the minor sue, nor can the minor sue. Of course. But today, minors access the internet. They get into a website and they order issue बहुत बढ़िया है इसको order करें. That still may be on 11th or 13th. And I was giving an example of somebody, there is an institution known as Khan's Academy. I don't know how many, I didn't know it honestly. 6 years ago, when my grandson was only 6 years old, he asked me one day, said, "This is a mathematical problem, I want to tax Khan's Academy." I said, "Well, I can't get it." He said, "Don't you know this? This academic computer tax engine," and showed me how to work out. Now, it would be unfair to get that kid and say, "You can't do it without your parents' consent." So consent normally understood for a minor is parents' consent. But parents may not be available. My daughter and son-in-law may be working somewhere as doctors, and they can't be told that, "Hey, I want to access consent." And that consent has been transmitted to their side. That's not possible. Therefore, one other method thought of was that there should be some kind of prevention which pops up. A pop-up which says, "What is your age or date of birth?" It is a smart. And I've been to all of you. So you give exactly the way you should get it. So the chap sitting in America or Germany or England will not be able to identify you. And you will have to get into a contract. But tomorrow if the contract becomes bad, because of Mumbai is the contract is valid, we cannot sue you to get money. That's not fair in business. Then, but one thing is there. Therefore, what do we do? So you have to determine who is minded, who is not aligned. In this country, there are actually somebody. There are different ways for drinking, different ways for marriage, different ways for cigarettes also it's voting. Different ways for voting. But generally, contract law has to discuss 18 is accepted as incorrect. So with all this back and forth pushing and pulling, the law is 18. 18 major acceptable. Look at here, I mean, you only 17, 11, and 29 days. It's illegal. Anyway, some arbitrariness has to be there is no escape. Then this question of take it or leave it. Now, some of these fellows, this concept of click, trap and click. So the moment you click it, you leave the accept. I don't want to give you all this. That's why you can't accept. That is not important. So there is a law which forces you to permit you to access without these other conditions taken both up or involuntarily. Then comes like the order of court, there is no escape from them. Courts are the ones that are running the country, so you have to use the court to get a court one. Then you have employment purposes. In employment purposes and other study companies for credit rating, it's a very peculiar issue. Now, when I apply for employment, not future employer wants to know what my antecedents are. Whether I am a criminal, whether I am incompetent, whether I am fraudulent, whether I have 3 bikes, all these questions are asked. Now, I can't tell him, I won't give you one statement. I'll give you information on your address and telephone number and my email address. Because his ability to judge my suitability for employment potential depends on him. What is the particular? Like in the case of a credit rating company, which considers so many of the our credit rating companies in our country are very like us in the blind. You don't go to anything except bank balance and financial transactions. So therefore, that means the consent may not be extended. Then full Fiduciary study like grant of registration. Now you want an Aadhar Card, you want some benefit of the Prime Minister, something or the other fund. You don't give all the then what is our purpose like Aadhar application? For conferring benefits of the principle, prevention and detection of crime. That is right? For detection of crime, you have to give that. Now, if somebody wants to know whether I stay in such and such a hotel, because they suspect that I am a fraudster, they have to be. Otherwise, we cannot give it to anybody. Then finally, whistleblowing is a thing we encourage. So there is no specific law in this country like in America or in England. So whistleblowing is encouraged because that brings in a sense of justice, a sense of balanced relationship. Then we go to the next. Then, as I said, processing divided into all operations, including mere storage. As a rule, it should give the considered meaning of principle. There are things like purpose limitation, time limitation. Say, for example, why is it time limitation? I open a bank account today. 6 months down the line, I said, I want to go into that account. I go to the bank account and then you need all the account that you are holding. Very justified, because there is one principle that I have as a data principle. I have a right to ask for deletion of data which is not necessary. But again, there will be an exception. If the bank manager will say, sir, but for income tax purposes, you have to maintain it for 7 years or 10 years or whatever the law says. Then the data processing law says, unless argument of intermediate you by seeking that will benefit. Otherwise, you can tell it to then there is an obligation to maintain its integrity, an obligation to maintain that it do not act and accept unauthorized. All these are obligations.
You were lucky that it has gone for 5-6 weeks.
I'm lucky that I'm moving up to 82 in.
But many things are not done. Like, but
then this concept of privacy very time. Now, private people very complicated, we are putting it very simple. Tell everybody in your community that you must protect the privacy of data. Now, I don't know how many of you have heard of the famous Vishaka judgment, Vishaka judgment was a judgment of the Supreme Court when there was no law, saying that sexual harassment of a woman at workplace is an offense. The added one thing that there should be by design, in the sense you must compulsorily every company, every workplace has a notice in informing all the employees that this is what is to be done. This is the manner of dealing with employees, and in case of any objection, there should be how it is reported to and how it is come forth by women and all that. That is privacy by design. So everyone should be told that it is necessary by the law of this country that we should have privacy. Of course, now there is no law that but you have to start getting up and start better tightening your belt or shoes or whatever. So that tomorrow when it comes up, you are ready. That is privacy by design. Then what we have to do, educate all of us for again to adopt. Then put into place such cyber security measures as will effectively safeguard security data. Now, you will ask me a question and say, what is the effective process? That's the law of the The law is says, you will make sure your obligation is to ensure that it's safeguarded. What technical process you want to adopt, you can do it by a process because until years ago, other processes were used to take it. Then ensure a completion policy, notify data for information. Now, we have said that there should be an authority on data protection authority who interact with the sector of people and then finalize best practices and please not regulations. Now, that is one. Under the new act, instead of data protection. Mine is not working.
Working.
So it's going to be data protection. There is what is already data protection. Now, what I have to say about the present act is the data protection authority was considered to be a regulator. The regulator is an independent autonomous authority, already ultimately answerable to the government, who will ensure that the law is monitored, implemented, and also ensure that it is given to the issue. Now, instead of that, there is data section which is supposed to be, and then click on the consistent it is not a my only objection to that is that it is full of government knowledge. You don't even know what they want to do, who is responsible, they appointed, and what mandate was. Everything will be done by government. We have suggested the original report and the original hospital but the data protection authority should comprise of an independent person by the judge. Plus, data protection professional, whether academician or practitioner or lawyer, and usually which would take a balance view approach, but that is not happened. Then you have, and we have also suggested that every other entity will be a person of data to have a data protection officer local, who will be answerable to the central authority for data breach. And data breach will be reported by time to the authority for the immediate action. Then we can consider the principle for other processes of data as a proper grievance written certificate as discussed. Now, two things have happened. One good thing that happened under the Act of 2022, 2020, and they have accepted the concept of a consent marriage. It is an interesting thing. Now, a person may be so busy as no time to consent to under. So, what do we do now? Take for example, there is a very basic business. So, he thinks with problems. Every time he doesn't have the time to go to the sovereign, time on the doctor's time, to the photo on. So, what do they do? They appoint a power of attorney order. The power of attorney order will go and do exactly what needs to be done. And that is good enough for enforcement in the court. So, this consent manager will do the same work that you act as a trustee for the consent of the principal. That is one good thing that is covered about it. Then classification of rights. Now, fiduciary can be very simple. You may be the small shop at the corner of your, or it can be something that processes millions of bits of information. So therefore, you can't apply the same rule for the tobacco shop and the biggest multi-billion dollar. Therefore, the character of the agency or character of the fiduciary has to be determined either by reference to the total volume handled or the total sales, depending on which classification and the law will apply strictly or loosely depending on the time whether it's significant price. Even in a financial institution, there are what you call a CP, significant financial institution. Similarly, the same concept here. And cross border, I've already talked about. This one I have talked about adequacy test. Adequacy test, we learn the time.
There are a lot of questions that are coming in. Sir, what are the?
No, tell me.
Sir, you can about 5 minutes. 5 minutes is fine. I'll take that question.
Oh, okay. Okay. I already talked about the exceptions. People can most of the data that the person is not apparently research and achieving comments matter a lot. Here all of the comments at the end of 2 years. But firstly, data protection authority has been. Now, unfortunately, already gone. The law is coming to put as in the government is just the government is already working. The government is working. Hopefully, in my life. We are up to 2018. Now, I'm not going to discuss the then 2009 is the 2022 this act right now. Act has not been notified. It has been criticized and heavily voted in the government. It contains override provisions for exempt in all revenue government departments, from any or all of the departments. Even the obligations to sector to provide the data is integrated security will not be ensured. The law exemption. And then the original idea was to ensure that the same protection for the that original intention. Then data protection board is expected to monitor data protection and it is completely within the government. No independence. Even the facial qualifications of the Sarkar is not hardware in the act. Critical data is modified. Data on the process by any lawful purpose is necessary purpose not qualified. So if I can ask you, Even when the doctor is like, I ask you, read the doctor is the one who gives it. You know it. The concept of concern manager is account of the concern manager. The Supreme Court declared from here. So when the chance to get rid of the European Court, I'll just talk about this at the end of it. Okay. PDP is very strict. So you cannot take away data of any of the person to Europe unless they come to the okay. There is a law, GDPR also says there is one united test already. Before you can transfer the data across the border, you must ensure that the country to which you are transferring the border has the same type of protection to the data that you are in. Now there was a lot of data being transferred across the Atlantic Ocean from Europe to America by companies. They are exactly what is known as the data sheet agreement, under which it was agreed that all the data can be transferred because they thought it is a test of it satisfied. No matter when ultimately to the European Court of Justice, the European Court of Justice said, hey, when the data goes into the American hand, the president can authorize any federal agency to access it without consent. So how is it adequate? It is not adequate at all, and that data sheet is completely negative and stopped. Now, my own feeling and my own apprehension is that this law comes about, and all government departments are exempted from figures of the data protection, normally expected of them. And some European governments say, hey, in your country, the like data can be taken away by the government for the asking without any inspection. So why should we agree to it? So this is a brilliant other question, which I am leaving with you. Please think about it, and we may utilize it for asking you questions, and maybe for the questions. Thank you very much.
Thank you very much, Lester. It was a great eye-opener for us because he has taken us through the evolution of data privacy and data protection act. So there are a lot of questions that are coming in both online and probably in person. So I'll just take a couple of questions which have been posted online and then come back to in person. This question is from Medha Sharma of Infosys. It's a very interesting question. Lot of interpretation around right to nominate available under the Act in the event of death and incapacitation of the data principal. Can you highlight the intent of having this as right? To what extent the rights can be extended to the nominee under the Act?
Nothing unusual, or extended to the nominee. Now, if I do suddenly, don't I nominate somebody to the bank account? That's something they try to do that government right. So they suddenly a member of a housing society. There is a right for that person nominee. Therefore, even the Act, when we question a question of who does the nomination, you have to answer somebody else to answer the question. And the person to answer the question is the person who says, I am fair. That is why it goes hand in hand with the consent manager. So this difficulty is not there at all.
So the consent manager is the intermediary to whom
If
this.
you want it, I can say that I don't, you can understand, I will not raise to somebody else.
The second, there are a number of questions from Milan, but I will take the one which is sort of very important. Now, Milan DP from DNA Technology Consulting. So this is related to your mall example. So the mall in which you are deemed to have given consent when you entered it. What limitations of processing can be enforced by television media or social media for using this deemed consent for disinformation or any other purposes?
How does it, television media, how does it get information in the first place? Let's take a concrete example. Let's say you are the anchor and you are having a meeting with me on the television, and police here is not something. Now, you can't use it unless you get my consent to use it in this way. I gave it to you only for the purpose of your record. You don't say that I'm going to use it for disinformation or legal information as well. So I don't think that question will be having this.
Questions from the audience interested? Yeah, over to you, please.
Definitely, Lordship. As you rightly pointed out, even though Puttuswamy gave us the right to be forgotten as intrinsic to the right of privacy, in reality, that very rarely happens. Even if I die tomorrow and somebody is nominated to take over my bank account, they need to prove my identity, for example. So I just wanted to understand from your Lordship, what really constitutes for us citizens a right to be forgotten?
No, right to be forgotten is slightly different. In fact, I wanted to exercise the right myself, and then the government will ask me to head all these committees. I want the right to be forgotten. I retired in 2006, 2020, the same thing again. The right to be forgotten is. Take a classic situation in this. Let's say somebody tried for a given grade for whatever, convicted, and subsequently the Supreme Court acquits him. Does he not have the right to be forgotten so far as the trial is concerned? But it cannot be erased. It is not. It will remain on the records of the court because the court's record cannot be erased. But the right has rectified into a better right because the Supreme Court has acquitted. He has the right to be forgotten as far as the trial is concerned. That is different. So your example was not right to be forgotten. When I die, my bank account, I am not forgotten. Then put my picture there and put other things. Like another matter. I got forgotten because Shakespeare told us something very interesting. He said the evil that men do is the good is of intelligence. So I remember for all the evil things that I've done. So how can you forget?
Any other questions from the audience?
Sir, if I may. So I actually have
Keep your
questions.
question short, because he works on whistleblowing, sir.
Okay, no,
Thanks, sir. So two questions. Firstly, we know that there's a maximum penalty of 250 crores being imposed. But I was just wondering, is there any time period for which that can be imposed, or is it for a specific case? Now, when we say a case,
so case, each infraction of the law, you are liable to report maximum. It shouldn't
so let's say somebody does a secondary use, and they're reported once by whistleblower, and they pay the case of 250 crores. Now let's say they repeat the same
exactly. That is my objection. Also, I didn't have the time for it.
Right.
If a person commits the same offense repeatedly,
Correct.
in criminal law, what do? You call it habitual offender and
And you put in the maximum.
But here the maximum point is 250 crores. Therefore, we have said, we will report to the number, particularly in the case of a foreign business company or MNC, the maximum penalty can be 5% of the total global. Which was some correct minister. Number two, in the case of a government department, the person in charge of the department is the best responsible. Now, if you notice all the department.
Okay, and so my other question was that again talking about transfer of data. So not only transfer of data, transfer of rights. So when I'm, let's say we talk about Google or Apple or something like that, and we talk about the Indian arm.
Yes.
So let's say we impose a penalty on the Indian arm.
Yes.
And the Indian being does not earn enough that it is able to pay the full penalty. Now, will the balance penalty be paid by the actual company?
What happens?
Okay.
I told you, if the expert editorial,
Correct.
if the one sitting elsewhere constantly is, let's say, bombarding the Indian people with it, one can even go out and say, hey, you're also within my country. And what such a thing? Now, for example, you are very peculiar laws. US, how it was an extraordinary, you may never have set foot on US soil. But if you have sent money to somebody in US, it would have gone through one of the banks, correspondent bank, it would be a dollar denominated bank. The law says that is good enough for them to hold jurisdiction against you. And they will issue a warrant against you, and warrant will be executed, of course, thanks to all the MLA and all that,
Hello, sir. Yeah, right side.
Where,
So recently, 18 some crore something data is leaked on COVID website. So how this act will perform on government or something?
So government says, no, under the act is not, first of all, even today the act is not applicable. Because notification is much. Number two, the government can say, hey, this act is not applied to my departments at all. Then what?
So what is your suggestion, Bill?
It could apply to law. That's what we had said in terms. That whether you data is with government department or a private individual or a company, private company, across the board it should be the same law.
And can you say something about the process or the committee and government related to this process or act related? How actually process is happening during government and committee?
I don't know. You mean under this new act? I talked about.
And more general question related to this.
I talked about how the whole thing started and then our bill was.
Yeah.
Okay.
Yeah.
That was the process. Now, normally that should be the process to be followed by any high power body. But I don't know what process has been followed because it was never public science, it never public. I have no idea who is doing that.
Okay, thank you.
Other questions from each person? Yes, Professor Raman.
Yeah, hello, sir. How would like outsourcing these, for example, so suppose an Indian company wants to set up a call center or data center in Philippines or something like that, right? So in that case, how would privacy laws actually work? I mean,
So the question that was asked to me by Wells Fargo and is a public thing. See, Wells Fargo has an establishment in India, I don't know what they do, what was it they do. And that is exclusively in respect of American. They are not dealing with the local people at all. So they asked me a question, right answer, why should we be government? I said, yes, we should not be government, because we are not dealing with anybody, any Indian data. Unless you start bombarding the Indian people and saying, deal with Wells Fargo, take Wells Fargo, whatever this product. When you go to America, please get money in Wells Fargo. Something like that, advertising. They won't do it. So similarly, we are confident, but you're talking about the reverse case.
yes, I'm talking the reverse case. Indian company dealing with Indian data, but they have an outsourcing with some service provider.
Specific answer to two levels. Is the Indian data being according to the law in India? Has it been sent across the border in accordance with the law of India? Number one step. Second is when the data has gone into the hands of X country, X country. The X country have the same sense of adequacy that we have. The adequacy is not that you can grow water cannot be done. Should not be done, cannot be done. Now under the law it is possible. Unless it is prohibited. Now problem is they are prohibited only Pakistan and China, nothing else.
Other questions?
Thank you.
Here is the mic.
Thank you so much for that talk. I just wanted to reflect again on what you were saying about how the law is not applicable to the state. But at the other extreme is the case of when they say it is applicable, which is around right to information. So I just wanted you to reflect on
See what has happened is right to information was also considered and declared to be a fundamental right. They said it's traceable to 19 million. Now this is a classic situation where two fundamental rights coincide or collide. 19 money and against 21. Now some kind of a compromise has been made. Now under the RTI, that is the Right to Information Act also, there is a very general provision that even personal data can be furnished by what you call an information officer. If it is something that the parliament would have been entitled to work on, it is not. Now, I can use that here. Saying, hey, parliament would have been entitled to work. See, basically, look, ultimately, why is personal data called? Personal data is called into question in order to assess the activity of the government office. Otherwise, what is their parliament? Now, suddenly, I was head track in a government department, and I have got 4 buildings in Koramangala. Then somebody asked a question, where did you get this money? What is this happening? Easy that. Now, one objection can be the personal data. But then the overriding is, if it is in public, there is a overriding provision. If it is in public interest and something that parliament would have been entitled to us, we not even given. The same thing will apply to data this DPDP Act also. If that section 8 is a small window, that a person is still there. Not applicable. The act itself is not. The PDP Act is not coming. When it comes to courts, there will be this ultimately the job of balancing the order of the courts. There are 2 fundamental rights. One person saying it is a fundamental right, another person government saying it is not your. So whether it is publication or online gambling or marketing, online marketing is always there is somebody at the dollar and something.
Any other questions? Sir, Shyama.
Good afternoon, sir. Sir, my query is on the clause that the data should not go to say countries like say China or so. In case, say for example, we had a recent trip with say Canada, where our diplomats' data was say open, put up on the posters and all. So in such cases, suddenly there is an adversary coming up. Let us say. How do you deal with such?
Hey, you can't do anything to the diplomatic person.
No, I mean like suddenly our data has gone there.
You can do nothing about it because data are not with the diplomat side.
No, so some data from our country is in Canada, and we now want to close those channels.
You can do it from tomorrow, don't send the data, that's all.
Oh, okay, we can whatever has been own data. We not restrain them not to use the machine.
See, the understand one thing, in international law, each country is a sovereign. No sovereign is subject to another sovereign. It's only by mutual agreement that you can say, you can enter into an agreement with Canada and say, sir, please give it back to me. Like what Tipu Sultan sword. Tipu Sultan sword is the Indian one, but lying in the British Museum. Now we have been begging the British government that please give it. So each person says, I'll get it, now you'll get it, I'll get it, nobody gets it. He gets votes already on that footing. The politicians are using it to say, I'll get back to Tipu Sultan. He will say, I'll give back to Tipu Sultan always to vote. So that there, the government may say, no, if you remember, the US government has permitted certain museum artifacts which were stolen and kept in the US metro museum to be brought back to India. That's the government, you can follow this. But that has to have some kind of an agreement between the two sovereigns.
We'll just have 2 more questions.
Hi, my name's Lily. So you put together this whole, report, and everything. Were there any topics in the putting together of the report with your commission that you didn't get to, finish due to pushback or due to legislation just not being ready? I guess where is data protection going in the future?
Okay. We did the exercise, put together a report, drafted out the bill, and said, hey, this appears to be a nice way. It doesn't go the extreme to the extreme of GDPR, that is not as strict as GDPR. Not does it put applicant name is no law at all. Not does it go in so many other ways, there is no law. This should work. Now, all legislation is subject to this kind of lobbying, whether it is in India or in America. It all depends on who pulls or who pushes. Now the MNCs were able to prevail upon the government and say, hey, this is disastrous. If this kind of law comes, our trading business will go fucking. They did not pass the bill. They didn't even put it in the parliament. They went round and round and round. And they came out with their own bill in 2018. That 2019. That was full of holes. And 87 amendments were suggested by the joint parliamentary committee. It became so complicated that what was originally cheese turned out to be chalk. So they dropped it. And now they have come out with the 2022 bill, which has now become Act in 2020, which is a very weak method of what was originally suggested. So cross-border, hey, you can do on all cross-border transfer unless we prohibit. But today, if you ask me what is the prohibition, there is no prohibition. One of them will turn around and say, don't design it on. Don't send it. But whatever you already said, do not restrict. That's exactly what is mentioned. And were there any other issues undecided by us? No. Whatever we could think of, human brain is has limited capacity. To that, we worked around it. And we said, do it. Now, even that was not done. We gave them a whole code class. They continued to teach us and then made it by the way. Pushed it.
So thank you very much, Mr. Since I am the moderator, I have to ask a question. Can I? Okay. So one thing is about right to be forgotten and right to erasure, which is strictly enforced in the DPDP Act. And that has been watered down or actually removed in the DPDP Act. And what do you think about what's your opinion about the validity of enforcing something like right to be forgotten or right to erasure in law? Because looks like there is a lot of time dimension to data that we share with. I mean, it has, it can go on endlessly, and therefore, is there any meaning to the right to be forgotten or right to erase in this country?
Yes, right to be forgotten is a right. There is not, in fact, if you remember, Supreme Court has said every human being has a right to be forgotten, a right to be left alone, a right to be left alone. That is recognized as a principle. Now the question is, there is a limitation. As I told you, I may say, I may go to the bank and say, close my account, you will close the account. Then I can tell him also and say, erase all the data. Now, you can say, I will give this data for life for 7 years because the income tax act is going to be issued by the courts. Fair enough. If there is a parliamentary legislation which requires it to be kept, it can be kept. Otherwise, I have a right to that one. I don't want to be bothered with this back. Now, with regard to the other issue that I was talking about, one has been acquitted. Why should you now talk of my trial? Yes, I was tried. I was convicted. So I don't want to go into politicians' case. You also know what happened in the politicians' case. Very famous politicians. We spent for 2 years to almost nothing. How did it happen? It happened. There's clear promises first. What ultimately look. Law is not decided by a computer. Law is not decided by a mechanical contrivance. Law is not subject to a mathematical equation. Where you cannot say, of course, even mathematics also need to all this percentage. Now that enough of mathematics. So I would accept the argument that mathematics is law percentage. Physics has whole lot of percentage. Not very lot of percentage. Then there is a man tried, convicted, that of honorably acquitted by the Supreme Court. Yes, right. Yes, to be forgotten. He to be forgotten incorrect.
Thank you, sir. Thank you very much for enlightening to our questions and answers. I now request our director to present the members group of our appreciation to us. I request Professor Srikrishna to propose the vote of thanks.
Sir, on behalf of IIIT, a director, extra faculty, students, staff, and all the audience here, sincere thanks to you for this talk, illuminating and informative and engaging talk. Particularly appreciate that you flew down all the way from Bombay just for this talk, and really enjoyed the interactions we had even before the viewing. And I think like you mentioned, all of us in technology space really need to understand this area. I think your talk has sure helped everyone move a little forward with that, and you probably also opened up lots of questions for people, which is always good. So, yeah. Okay. I'd like to also thank all the audience here, all of you showed up here in good numbers, and also many who have joined online and watched this, both from our IIIT family and outside. So thank you all, and I hope to see you again for the future Samvaad talks, and thank you again.